Wow. So I would be, well,
oh yeah, I mean you can, I don't know if you can make it mad, I think the resolution is not straightforward. Yep. I do, but I don't. Yeah, I recommend it if you're Marta.
Welcome everyone to the fourth seminar of this series. We're very happy to have a speaker today, Marta Rodriguez de Assis Machado, who is a visitor here at the law school, who will be speaking on the battle for abortion rights in Brazil's state arenas from the period 1995 to 2006. Professor Machado has degrees in philosophy and theory of law from the University of Sao Paulo in Brazil. Since 2007, she has been a full-time professor at the Getulio Vargas Foundation Law School in Sao Paulo and is a co-director of its Center of Studies on Crime and Punishment. She is currently also a senior researcher at the Brazilian Center of Analysis and Planning, a global fellow at the Center on Law and Social Transformation of the University of Bergen in Norway, and one of the principal investigators at the Maria Sibylla Marian International Center for Latin American Conviviality in Unequal Societies. I like very much that title. Her research is situated in the interdisciplinary fields of law, political science, legal sociology, focuses on the relations between social movements and law, and the ambiguous role criminal law plays between recognition and repression, which is obviously important for the topic of her presentation today. We're equally very pleased to have Rebecca Cook, Professor Rebecca Cook, here as commentator. She doesn't need introduction in this setting, but let me simply emphasize she's Professor Emeritus, Faculty of Law, Faculty of Medicine, the Joint Center for Bioethics. She's also the co-director of the International Reproductive and Sexual Health Program at the University of Toronto, which is internationally renowned. She's ethical and legal issues co-editor of the International Journal of Gynecology and Obstetrics, serves on the editorial advisory boards of Human Rights Quarterly and Reproductive Health Matters. She's the recipient of numerous recognitions, including Certificate of Recognition for Outstanding Contribution to Women's Health by the International Federation of Gynecologists and Obstetricians, and other awards. But maybe important to mention here as well, to make some publicity, she's also the co-author with Professor Dickens and Mahmoud Fatala of Reproductive Health and Human Rights, Integrating Medicine, Ethics and Law, published with Oxford University Press, but which has been translated, I think, in already 5 or 6 or more languages, and so it continues. Without further ado, Marta.
Yeah. Thank you so much. I'd like to start thanking Rebecca for receiving me here in this semester. It's been very fruitful dialogue. And thank you, Trudeau, for inviting me to present my research here. It's an ongoing research, so I would love to hear any insights, critics, and ideas. It's a privilege, and I'm very thankful of your patience, because as it an ongoing research, I have still doubts and questions and everything. And I teach law in Brazil, and I'm originally from criminal law. And when I started researching social movements, I was puzzled by this question: why progressive social movements are asking for criminal law more and more? And I was thinking about this ambivalence of law, because I started with the Brazilian Black movement, the same movement in Brazil that is the same population that is selected by the criminal system, and when they were trying to fight about an anti-discrimination legislation, they wanted criminal law. So I was very puzzled about this question, and the general question of the ambivalence of law, how it maintains status quo, but it also can be a tool for transformation. This is my general question. I've been, then my research went a little bit from the socio-legal studies because I was interested in this relationship. And then I arrived to this field of abortion battles, and I found ambivalence in a slightly different way. It's not anymore the same instrument that criminalizes, but also means recognition. But then we have an ambivalence in a way that we have human rights on the other side, that is a traditional progressive field being used by the conservatives. So it's my general, it's a new field with very different stuff, because here in the things I have studied before, we had progressive movements fighting against the states to have public policies implemented, and here we have movement and counter-movement playing and disputing the same strategic field. So it brings new challenges to thinking about the relationship between social movements and law. And well, coming to the subject, abortion, for those who don't know, abortion is a crime in Brazil. And since 1940, it's permitted under two exceptions: risk to life to women and rape. Most recently, in 2012, we had a Supreme Court case that created one more exception if the fetus is diagnosed with anencephaly. Attempts to expand and restrict this legislation have been taking place, most importantly, since the 70s. But the National Constitutional Assembly in 1987 to 88 was the first moment that abortion was, that somebody talked about abortion in a public institution as a public policy matters. It was really a taboo. We had some women that were mobilizing and trying to get legal abortion implemented, but it was like lobbying in some commissions, in the Ministry of Health. It was something really undercover. So the first time the subject really came to public was the National Constituent Assembly. So what I'm doing here is trying to retrace this 30 years of battles since the National Constitutional Assembly until now, trying to retrace the political process on abortion rights, focusing on both mobilization and counter-mobilization in different state arenas. But of course, I'm a lawyer, I like to see state arenas too, mostly. It's also the first attempt to rebuild this political process in Brazil. We don't have a narrative of what happened in the 30 years. We have some sparse texts, or a lot of activists have written about this, but we don't have a narrative of this, a complete narrative of this year, and even less is produced on the counter movement. So the idea is to observe this broad period of time through, I'm using here the social movement literature of the sociologists. So I'm working with Machado, Tilly, and Terrell, and so they have this idea of bringing a relational approach to the study of social movements. So mobilizations arise always in contextual field, which have supporters and contenders, and it's important to understand movement and counter-movement to understand the whole battle. It's contextual and dynamic, meaning that the balance of opportunities and threats are constantly being altered by mobilizations in the field, and institutions and state are a crucial part of the conflict as a target of demands, sometimes as an object of dispute, and sometimes the state is the contextual space itself. Yeah. I'm working also. I also brought this idea from the sociologists, the idea of arenas. as social spaces with different political resources, different levels of formalization, rules, codes of actions and language. So I consider arenas as the street, public campaigns, media campaigns, parliament, courts, the executive, technical, professional institutions. And the idea is exactly to see how actors move through different arenas according to their perception of opportunities and threats. And also how there is an adaptation of tactics and strategies and frames when they move through these different arenas. They also give different mobilization resources. If I go to the international norm, I get international document. If I to international sphere, I get international document. If I go to a technical institution in the Ministry of Health, I get an administrative norm, and I can have a Supreme Court ruling. So there is a very interesting. There is also a very interesting interplay when actors seek sometimes to annul one victor of one side, going to the other sphere where they can get a resource with a stronger authoritative force than can. So the battle is interesting also when you see it in juridical terms, because we see this interplay between different norms with different authoritative power. So this is the idea of the broader idea of the research. I'm also working with the definition of legal mobilization that Machado gave, which is a little broad as the traditional definition that is court-centered, and that I think that what he tries is to say that the systematic study of socio-political context is essential to understand the role of law in the dispute. So I try to connect how legal mobilization takes place and how discourses are built inside the law field, but also to understand it in the context. As he says, how law matters depends on the complex, often changing dynamics of the context in which struggles occur. So I try to connect both things and try to see what comes from what I can get more from this broader perspective. It's not court-centered, so the idea is to observe legal mobilization in different arenas. In the abortion field, for example, the administrative mobilization, legal mobilization in administrative spheres and medical spheres are very important. And also the use of rights in informal arenas. I also consider this legal mobilization. How now street campaigns or media campaigns are using the language of rights. The idea is also to see how legal discourses intersect with extralegal frames and symbols, and they affect one another. And I think another idea is to see legal mobilization not only from the strategic point of view. That means it's not only about getting decisions and precedents and injunctions, but also consider its constitutive role. So how battles in the judiciary have a constitutive effect in the identity of groups, in the strategy of groups, and also in the public sphere debate itself. So from this attempt, it's still an attempt to connect a sociological literature that doesn't look to law very close and doesn't talk in our terms. So I'm trying to connect these two fields. I expect to see this relationship between movement and counter-movement, so how they react to each other, how they adapt strategies according to the other side victories, and how they also adapt frames according to the other side discourses. I also expect to see the circulation or the adaptation of frames in different arenas. So sometimes formal arenas often asks some formal requirements, and this changes the discourse. And also formal arenas normally asks a moderation of the discourse that we have in the street. So I also like to see how strategies and discourses and frames are are circulating and also being translated. Sometimes a discourse that is used in the court goes through the street and it goes like this. In this point, I'm particularly interested in seeing if the battle in the legal field has, which are the specificities of the battle in the legal field, but also how the battles in the legal field affects the other arenas. And then I think the third thing that I want to discuss, and something that I want to discuss here, it's try to have a broader view of the effects of litigation. Like what public hearings or what formal manifestations and decisions have besides the case, the court case. So I kind of see courts as a stage with a resonance box. So it has what kind of effects it can irradiate. So this was kind of trying to explain the theoretical stuff that I have in my mind when I designed the research. And what I'm doing now is I'll give you a very quick overview of the most important moments in the Brazilian dispute, the big shifts and the main political forces that were in play in each moment. And then I'll move to the Supreme Court, to the Supreme Court dispute, and try to make sense of this case and its effects. So the Brazilian Constitutional Assembly was a very important moment in Brazilian democracy, where we were leaving the military dictatorship, and it was a very, we had a boom of mobilization, like different social movements from different areas, indigenous people, women's movement, environmental movement. We have really a boom of mobilization, and they organized themselves to participate of the draft of the new constitution. So the feminist movement was always it was a reorganization, so to say, of the feminist movement to participate in the Constituent Assembly. The group was a very funny name. It was named the Lipstick Lobby, the feminist group at that moment. And it was in fact, it was a very complex movement, because this moment of the Brazilian feminist movement, we have middle class, urban, and educated women, most of them that just came from Europe, from exile, and they had these ideas of gender equality and questioning gender roles. But we also had poor mothers on the periphery, and they were trying to mobilize together, and the mothers, they just want to have better conditions to be better mothers. They were not really questioning gender roles. So we were a mixture of this. I think we still are a mixture. Feminist movement, Brazilian feminism is still a mixture of these two lines. So in the moment of the Constitutional Assembly, like, they have some equality questions so important, like the women couldn't sign a contract without the authorization of the husband. They had some questions that were so crucial that the movement was very divided, and they wanted to focus on this minimal agenda, feeling that abortion was controversial inside the movement and it was like too much. They were not so confident in bringing abortion to the discussion. But the Catholic Church decided to take it, as it did in many countries in Latin America in the same moment of drafting constitutions. I think not only in Latin America. They were pressing to bring the protection of life since conception to the text of the Constitution. So the feminists had to react, and so the subject was highly discussed by both sides in this forum. In the end of the day, they negotiated and they agreed that both demands, because the feminists, as a reaction, they also wanted to have an article in the Constitution claiming free planning, and that meant also allowing abortion. And in the end, after a negotiation, both sides left the idea aside. The Catholic Church had other victories. For example, we have Catholic Church in public schools. So they had other victories too. So the subject was out of the Constitution. But anyway, the Constitution was a very important moment to provide what I call legal and symbolic weapons to the fights that would come ahead. The right to health in the Brazilian Constitution is really important. The human rights agenda and the judicial review mechanism that will be used in the following years. If you look at the debates at this moment between the feminists and the Catholic Church, we basically have two main frames. Right to life, and it was the Catholic Church, and they were defending right to life with a religious reasoning. And the other side, women health. Like the feminist movement, abortion was just a question of women health, and that was the frame that they used. In the 90s, we had, I would say, a continuation of this moment of optimism towards democracy and rights, what I call the era of the United Nations conferences. So the United Nations Conference were also an important event that made the feminists organize themselves. They were mobilizing and organizing a lot of preparatory meetings, and they were going to the conferences and participating and bringing back the results and the vocabulary of the international document to press national authorities, but seeking names as a boomerang effect. So we can really see this decade in Brazil that was the focus of the feminist movement, was going internationally and coming back to pressure the executive and the legislative. And we have the most important ones in Vienna, 1993. I would say one of the main legacies that was brought to national discourse was the idea of human rights of women. In Cairo, 1994, they started to talk, like the human rights of women comprise also reproductive rights and reproductive health, and we internalized this discourse as well. And in Beijing came into play also the idea of sexual rights. So the expression sexual and reproductive rights, that was an interesting shift in framing that we have in the beginning, family planning, and then women's health, and here we start to talk about human rights of women, sexual and reproductive rights, and reproductive health itself. At the same time, the same decade, the pro-life movement was also developing international alliances. So we had mainly the Catholic Church here. At this point, we had mainly the Catholic Church as the main actor, the main pro-life actor. But now in the 90s, an American organization called Human Life International started to support, not only in Brazil but in many countries of Latin America, a lot of the creation of many small local pro-life NGOs. So they were supporting and giving strategy and material and money, etc. And we also had Catholic and pro-life lawyers circulating in the same international forum that the feminists were trying to occupy. So basically, they were in the national arenas. The feminists were trying to get something very simple. We had, since the 1940s, we had the illegal abortion in these two cases, and it was until this moment, until the 90s, we didn't have one regulation about that. And so, in fact, in practical terms, it was very difficult to assess legal abortion. We had no direct. We had some, like 2 hospitals in the whole country that would perform legal abortion, but not really an effort to implement. So first thing they tried to, they saw the opportunity two democratic governments that were open to the feminist movement to press the Ministry of Health, to press for the regulation, for the technical regulation to implement legal abortion. So in the Fernando Henrique Cardoso government, it was in 1998, we had the first technical norm on legal abortion, saying that it should be performed in the public health system. And it was, like, of course, a victory. But in the Lula government, Lula was the candidate of the Workers' Party. He was linked at that moment, especially linked to all the social movements that were that I mentioned before, that were formatted in the constitutional moment, and he opened a lot of space for social movements in his government. In this subject, he just nominated the main activist, the main pro-life activist, to be the responsible for women's health in the Ministry of Health. So in this moment, the pro-choice agenda advanced a lot. Mostly in terms of implementation of legal abortion. And he issued, in this moment, it was many technical norms, very advanced technical norms, really facilitating the access to women to the service. For example, in case of rape, women doesn't need to present the police report. The doctor should trust just in her word. So we had a great advancement in this field with what they could do in terms of legal abortion. And in this moment, the executive was very powerful. And one of the issues that they decided to do was to form what they call a tripartite commission with members of the executive, the legislative, and the social movement to discuss and to draft a bill to decriminalize abortion. So that would mean that this would be a bill that would be presented by the executive, and the executive would use its power of negotiation with the parliament to approve it. That was exactly what happened with our statute of domestic violence. We didn't also have a regulation on domestic violence. The feminist movement pressured and had space in the executive, and the arrangement was more or less like that. The executive would present a bill of law supported by the social movement and use its power of negotiation to approve it in the Congress. So this was really a moment where the pro-choice agenda got to the most advanced point. We could say there was a real opportunity, there was a real possibility to pass a bill decriminalizing abortion to 12 weeks. What happened just right after that? So before I go to the backlash, the legislative was also an arena used a lot, but mostly for the conservatives. This is very interesting. They used the legislative always to try to reverse the advancements the feminists were getting in the technical norms. So they would, after a technical norm allowing legal abortion without a police report, they would present a draft trying to change this regulation. So this was more or less the development. The feminists were quite happy in the advancing the field of legal abortion, and also surprisingly there weren't many bill of laws attempting decriminalization. Before this one, that was serious bad. We didn't have many attempts of allies of the pro-choice movement to advance the regulation. But what happened, if you study, I am studying all the bill of laws presenting and also the frames and everything, and what happened, what you see here is that we had like pro-choice bill of laws trying to expand legal abortion. There was many bill of laws trying to expand legal abortion to cases of fetal malformation and to an anencephaly, diagnosis of anencephaly. The one side attempting to expand the legislation, the other side attempting to regress it, but nothing moved in the legislative. Nothing ever happened in the legislative. I think the two sides were locked in a, in a game of power that nothing really happened in the legislative. But what happened in the 2005-2006 what we see a reversal of political opportunities for the pro-choice movement. Lula's government and the Worker Party was involved in a corruption scandal, and many progressive fields were affected by this. So not only the abortion and the feminist cause, but also environmental issues, indigenous people issues were suffered a backlash from this moment on, because Lula had to, in the abortion field, he had to reconcile with its basis, which mean the Catholic Church that we had in Brazil. In Brazil and Latin America, we had a branch of the Catholic Church, the Theology of Liberation, that was very linked to the progressive field. So, but they were not, of course, they were not happy with Lula advancing abortion rights. So Lula had to try to reconcile with the Catholic Church, try to reconcile with public opinion that was also not in favor with the expansion of abortion rights. And he had to negotiate to support with the Congress, with very traditional interests in the Congress. So the outcome of this process was the total retreat of support of the executive to the pro-choice agenda. And it also involved not advancing the draft decriminalizing abortion to 12 weeks. Parallel to that, 2006, also as a reaction to the advancement we had and to the almost passing of the bill legalizing abortion, the opposition started to reorganize itself in a very, it started to reorganize itself in new bases. So they founded this national movement, Brazil Without Abortion, which is it's a national movement with a strong power to mobilize in civil society. And they were like organizing the work of the local pro-life organizations, and they were also convening annual marches, which were really massive rallies of people going to Brasilia and protesting. And public campaigns, they were very important. In the 2006 campaign, when we had we have elections for president, and they really started for president and for Congress, and they started a powerful campaign distributing the deputies that were for life. So the campaign was Vote for Life, Defend Life. They were really showing you which candidates were abortionists and which candidates were pro-life, and etc. And of course, the Workers' Party suffered a lot of electoral damage because of of previous pro-choice positions. And this is a very interesting moment because with the marches and the campaign, the pro-life took the subject to the public sphere. Like the feminists were mostly working like in the backstage, trying to get technical norms and advance in the backstage, and they were not really mobilizing the public sphere. What happened here in 2006 that the pro-life, the subject went to the public sphere and to civil society talk and to elections and to campaigns by the pro-life, by the hand of the pro-lives. They also formed a parliamentary pro-life and pro-family caucus. They founded it in 2006, and it's renovated each legislature, and it increases in every election. It increases, especially because of the evangelical candidates that are very, very powerful in getting votes from the church. They mobilize against abortion, but they have a broader agenda against what they call gender ideology. So same-sex marriage, any stuff regarding gender equality, they would mobilize against this. They have been since 2006 presenting what they call the unborn status, which means the total ban of abortion in Brazil, and they presented many other attempts of amending the constitution to put the life since conception. So they have been advancing some pro-life bill of laws, and they were strong enough to rule out of our national, it was 2013, they ruled out of our national educational plan an article that just said that one of the aims of our educational plans was to gender equality and sexual orientation among race and social class, gender and sexual orientation equality. So they are really against anything that means for them gender ideology, which will destroy the families. So what we have here in this moment, just make a stop and try to analyze a little bit, some important shifts in the pro-life movement. So it has new mobilization structures and strategies. After 2006, we have this new feature, which is the pro-life movement trying to mimetize the progressive social movement in terms of structure, because basically it's formed by pro-life NGOs, also a lot of professional pro-life organizations like Doctors Pro-Life, Lawyers Pro-Life. And before we had basically the church. Now it's not only the church, we still have the Catholic Church, but we have a lot of non-governmental pro-life organizations. And also in terms of strategy, before it was basically the church lobbying and getting allies in the Congress, and now they were really organizing massive marches and public campaigns. I mean, the two big shifts in terms of strategy was going to public sphere, mobilizing public sphere and civil society, and going to the judiciary. I'll talk about this in a while. We also have, if you see the bill of laws, it's also very interesting how they changed the regulatory frames. Before, they were more focused on passing rights to criminalize more broadly abortion, or to get higher penalties for women or doctors. And now the regulatory ideas were more complex. They had bills expanding the fetus rights, the child's they use a lot the rights of the child. They had also some bills like offering social assistance to women, but only to that women that had the right to go, that for example was raped, had the right to get a legal abortion, and denied the legal abortion. And they were even addressed, like in the justifications of the bill of law, they were even saying maternal mortality, which was something that the feminists were saying this forever. Maternity mortality is a question, is a huge problem. A lot of women die because of unsafe abortion, so they would have measures to persecute more steadily the illegal clinics, for example. But they were using these frames that the feminists were using. They were using these frames of protection of women, or giving us social assistance to women. So they were even stealing some frames of the feminist movement. And I think a big thing is that it changed completely. The religious discourse almost disappeared, and you have mostly the scientific and the rights discourse. And what I will argue next is that the Supreme Court case was crucial to enforce this change into the scientific and rights discourse. First time a case arrived to the Supreme Court was a pro-life mobilization, a conservative litigation, trying to reverse, on a case on anencephaly, trying to reverse a decision that authorized determination of pregnancy in this case. The case didn't went on, but it was clear that the conservatives were interested in going to this arena. So After that, the feminist movement were like really very fast. They didn't lose the opportunity to frame the case, and they presented a constitutional challenge on the same subject in 2004. So it was the anencephalic fetus case. It was judged only in 2012. And it reached a peak of mobilization in the public hearings. We had 4 days of public hearings that was broadcasted nationally and via YouTube, and society was really paying attention to that. In 2008, we have a lot of both sides were talking this in the public hearing, and the case was judged favorably to the pro-choice movement in 2012. After that, we had, it's not here, but we had in 2005, the conservatives, we had another attempt of conservative mobilization. There was a law authorizing and regulating stem cell research that was approved in the parliament, and they tried to block the law. They offered a constitutional challenge against this law because life should be protected since conception in the Supreme Court. They lost the case in 2008. It was not an abortion, but both sides were mobilized to discuss this case too. And we have now 2 cases pending. In 2016, the pro-choice movement tried a case, constitutional challenge to argue that a woman if the fetus, a pregnancy diagnosed with a fetus with macrocephaly resulted from Zika, would be allowed to terminate the pregnancy. That's a very difficult case. I can discuss it later. And in 2017, we finally had a case asking the criminalization of abortion until 12 weeks. I will go very fast to the anencephalic fetus case, trying to understand a little bit of the design of the case and the decision and what I think are the results of the case. The pro-choice movement had a very, very moderate approach. They kept saying it's not abortion. It's a non-viable fetus, and the fetus will die not because of the procedure, but because of the malformation itself. So it's not abortion. We are not talking. We are not facing here the moral questions we would face if we had a viable fetus. They framed a lot the case on human rights and torture, because blind a woman to be 9 months pregnant of an anencephalic fetus would be a lot of suffering. And they brought a lot of women to the court. That was very interesting. It was the first moment we saw women in the court. Of course, we have 11 judges and only 2 women, and we have women in the court saying how was it like to carry this baby and what they felt, and it was an interesting moment. So they were basically arguing torture and the argument on dignity because of the suffering of the women, and they were defending themselves, saying that anencephaly was a very different situation from the person of disability. Because the other side was saying a lot. So here I took this argument from the initial petitions, from the petitions and from the public hearings in general. The other side was basically saying this is life and we have to protect life. We're comparing the situation to, of course, it was bringing the subject of eugenics, and comparing this as to genocide, crime against humanity, human rights in this sense. We're also advocating about the dignities of the life of the fetus, and also bringing the equality argument, saying the eugenic feature of this procedure would be discrimination against people with disabilities and so on. So what we can notice is that the pro-choice was very moderate. Autonomy and right to choose was very residual, or they almost never used, and equality is absent. Abortion is not a question of equality. While the pro-life movement used this space to reinforce their core frame of protection and dignity of life, They were very strongly disputing the human rights language, and they had the monopoly of the talk about equality. So the Brazilian Supreme Court, it's a majority court, so it means that we don't have a final ruling, a final decision of the whole court. We have different votes, and we get to a score based on majority. So it's kind of a mess to understand the rulings, because each vote has different arguments, and they get to the same result through different arguments. So it's a 400 pages decision that I tried to reconstruct the arguments and reorganize it like this. So it was an 8-2 decision. Some judges decided not to vote. So the 8 judges that were in favor of the pro-choice, of the termination of the pregnancy of the encephalic fetus, they were saying at the same time, but it's not abortion. We are not ruling here on abortion. What I think it was a very good legacy. 5 judges explicitly recognized mental health of women as a constitutional value. They recognized health, and health would comprise mental health, not only physical health. 5 judges recognized women's right to choose. 4 judges recognized that right to life is not absolute, and it accepts the balancing of values. 4 judges used the language of sexual and reproductive rights. 3 judges stated the importance of guaranteeing secular state. 3 judges were mentioning all the time human rights of women. 3 judges mentioned international documents, but really only 1 vote was built in the international, was like substantially grounded in the international documents. And it's interesting that he never mentioned CIDO. He mentions Cairo, Belém do Pará, but CIDO, it's never mentioned. 3 judges defend this argument that criminal law is not effective and the adequate instrument to protect the fetus. Only 1 judge talked about equality. It's not in the, although it was not in the core argument, and 1 judge talked about privacy. What I consider, this is something that I'm trying to do with Rebecca right now, to think about the legacies and ambivalences of this ruling. And I think some legacies is that we had for the first time the Supreme Court validating the idea that right to life is not absolute. We have for the first time judges, like 5 judges, saying that mental health is a constitutional value, that the right to choose of women is a constitutional value. The ambivalence of this is that they were saying it's not abortion, and then even when they were recognizing these values, they were balancing it against the non-viable fetus. So the women have the right to choose, and when we balance it with the non-viable fetus, then the right to choose has to prevail. So it's kind of ambivalence here. It was very interesting to see how women's perspective were taking the center of the judgment. Of course, there was not a fetus there, so women were occupying this space. We were really talking about women's life and women's expectations. But the other side, the stereotype that was being reinforced was, again, the suffering women. And the women and the motherhood stereotype was also very important, because they were portrayed as women that it was not a woman that wanted to abort, it was a woman that wanted to be a mother and face this tragedy of having the fetus diagnosed with anencephaly. So it's also kind of ambivalence of the cases. What we see here, I try to compare what I call, like, if we consider the Constitutional Assembly as the first wave of constitutionalization of abortion rights in Brazil, and this second moment, there is very important shifts in terms of framing. Basically, the pro-life was defending life in a religious perspective, and now it's like life with a scientific and legal approach. They were talking about human rights of the fetus, dignity, equality, anti-discrimination, rights of people with disability, and even bringing the international documents on these rights. And the feminist movement less diverse, but it was using only public health, and now it's using human rights of women, torture, mental health, dignity, and autonomy. What I think is really interesting in this judgment is to see how the conservatives were really disputing the language of rights, and especially human rights. Like both sides were using the language of human rights, but I think one of the effects of this case was really to create an identification of the pro-life groups with the language of human rights. After this case, you can see this being used more and more. Now they use, for example, autonomy, religious freedom, and right to conscience to fundament, for example, the ban of sexual education in schools. I mean, I think this case was an important turning point. Of course, it was this is one of the things I like to see, how like the institutional constraint of having to argue their agenda towards a constitutional court that made them use this language of human rights, and then it's being used in a broader perspective now. It was also interesting to see what happens with the concept of dignity. I think it's something that Hiva Siegel has already wrote about that dignity has been used by both sides with a variety of meanings, like dignity of the fetus, but dignity of the women meaning autonomy to decide, not suffering, but also because there was a discussion on if the women had to go through the 9 months of pregnancy to donate the organs of the fetus. And then one judge said, no, this would be instrumentalization of the body of the women, so this affects dignity. So even very narrow meanings were also brought on dignity. And one judge was like really writing, saying, we cannot bring dignity to this case, because then in both sides we have dignity in place. So dignity it's not a good concept to solve this case. And in the end, I think it's also interesting how abortion has everything to do with equality and gender equality, and how it's totally out of the discussion by the pro-choice agenda. Who was monopolizing the discourse on equality was the pro-lifers. So just to really finish now, I think what the new conservative movement brings us to think is this, I think not only in Brazil and not only in this case, this attempt to resignify the human rights discourse, and it brings us to think about the challenge we have in terms of human rights. I mean, it's a challenge to the idea of human rights itself. I think it showed its limits, but it's also a challenge for us. I include myself as also a little bit an activist that took for granted that human rights was a progressive language only used to expand rights, and it's also subject to disputes. In that sense, I question if we didn't have a kind of formalistic approach to human rights. So we got the recognition of human rights, so it's just a question of having that implemented. And we, for a long time, obscured this dispute in the meaning of human rights and how it has a very ambivalent and disputable nature. So I think these are the stuff I'm thinking now, how conservatives are totally inside the political game. They are using structures of political participation that have been mobilized for progressive movements for a long time. They have been using the rights frame, and they are even disputing the human rights language. So I think it's a little bit this. Thank you so much.
Just a few comments. This has been very, very helpful, Marta. Marta and I are currently working on an article on abortion in the Constitution for a symposium edition of a Brazilian law journal on the 30th anniversary of the Brazilian Constitution. This is something that Richard Albert, who taught an intensive here this fall, is editing with some Brazilians. So this has been extremely helpful for me to understand an overview of not only a historical, but an overview of the kinds of debates and arguments that are taking place, that have taken place in Brazil. I have very little knowledge of Brazil. All I've done is to submit an amicus brief in the Zika case that Marta mentioned. So this has been extremely helpful. The only other thing I have done on Brazil is an article on a very important case, the Aline case, which is a case that was brought before the Committee on the Elimination of Discrimination Against Women under the Convention on the Elimination of Discrimination Against Women. This was a case that was brought on behalf of an Afro-Brazilian woman who died in childbirth because she could not access maternity care. So with that very limited view of Brazil, I thought that maybe a best way forward in terms of creating dialogue and debate is to understand, raise some questions to better understand the movements and counter movements. Why has this debate around abortion been so polarized, not only in Brazil, but certainly right now in Ireland? You've seen the polarization in Chile with a recent Supreme Court decision there. It is a very, very polarized, dichotomized debate. And I don't have any answers to that question, but I can raise some questions that we might explore together. So, because of the framing of the law, here as Marta explained, you have exceptions to the criminal code. In Brazil, you have the exception to protect life and in cases of rape. So because the law is framed as a way, is exceptions to the criminal prohibition, the nature of the frame of the debate always focuses in on what does life mean, or what does it mean to provide services in cases of rape. And you see this debate in many different countries. In the context of life, of the woman's life, we know that in Brazil, maternal mortality, death to women who are pregnant or are within 42 days of pregnancy, as a country, maternal mortality has a very, very high per capita maternal mortality rate, much higher than other countries of its socioeconomic level. It's not as though they haven't tried with better maternity care, with better folic acid, I believe, but it's an extremely high rate of maternal mortality. In part, I think the second cause of maternal mortality after maternity care, lack of maternity care, is unsafe abortion. Abortion is a very, very common procedure. 1 in 3 women will have an abortion. All the criminal law does is to make sure that it's unsafe. So, and we can do a great deal to reduce the number of abortions in ways that are consistent with women's rights, but many, they either export the problem or they ignore the problem. So in terms of the polarization, some of my work has been on how can we think about protecting prenatal life consistently with women's rights? Would framing the nature of the debate this way begin to at least narrow the gap between the two sides? At least put women maybe more in the center of the debate. To acknowledge women's credibility in this debate. Because of the polarization and the criminalization of the frame, women are by and large invisible. And one of the brilliant developments in the anencephaly case was how the advocates in that case brought women to the fore. I think it's the first case that I know of where women were actually telling their stories, which is a really very, very dramatic development. Most of these women in the anencephaly case, anencephaly, one of its causes is a lack of proper nutrition of folic acid. So the fetus has no chance of survival once born and usually dies in utero. So the visibilization of women in this debate is an incredibly important goal if we are going to begin to talk with each other. Now, maybe this is a question. I wonder whether the pro-choice side has not adequately acknowledged the importance of the state's interest in protecting prenatal life. It's a question. And push the state to think about protecting prenatal life in ways that are consistent with women's rights. There are many, many ways to protect prenatal life consistently with women's rights. I've already mentioned one, ensure that they have access to maternity care so they don't die in childbirth. There is a huge public health problem around what's called recurrent miscarriage, where women want to have a healthy birth outcome, want a wanted pregnancy, but they miscarry and they miscarry and they miscarry. It's a tragic phenomenon that is not well understood, not well researched, or not well recognized. The other way of, and here I'm speaking just clinically, and I'll get to the social determinants of health. The other way of thinking about protecting prenatal life consistently with women's rights is to reduce the number of stillbirths and to reduce the number of perinatal deaths. Stillbirths in their fancy WHO definitions for each of these, and I don't want to get into the scientific detail, but around the time of birth or immediately following birth, wanted infants die. And there, again, these are in the millions. I don't know what the exact figures are in Brazil, but they're all there. So those are some of the clinical ways that we could protect prenatal life consistently with women's rights. Essentially, those pregnancies that are wanted assist women ensuring that they have healthy birth outcomes. Other ways, I've mentioned health systems ways of providing women with better nutrition, particularly folic acid. We know that a social determinant of poor health outcomes is intimate partner violence. We know that women, when they become pregnant, for some reason are subjected to intimate partner violence. It increases. We don't know a great deal about this phenomenon. There's a few studies, but we could do more research and we could do more service provision around decreasing intimate partner violence. Finally, another way is to facilitate infant and child survival with better care around the time of birth. So there are many ways that we can protect prenatal life consistently with women's rights. But my question to Marta is, why hasn't this been part of the debate, given a very, very robust debate in Brazil about the need to reduce maternal mortality more generally? Now, I just want to say a few things, because I know time is running, oh yes, it is running, about equality. Now, in Spain, the 2010 reproductive and sexual health law recognizes the importance of reproductive and sexual health services specifically as a part of women's equality. And the Convention on the Elimination of Discrimination Against Women that I've mentioned specifically says that criminalizing medical procedures that only women need is a form of discrimination. And this has been concretized in a very important decision of the Committee on the Elimination of Discrimination Against Women, LC versus Peru. So a question, my second question to Marta is, how can we begin to open up the debate in Brazil and in other countries about why women's exercise of their autonomy, why women's exercise of their right to health has to be done in an equality framework. We know that in the context of maternal mortality and abortion, rural women are at much higher risk, poor women are at much higher risk, racialized women are at much higher risk, and significantly when it comes to pregnancy, pregnant women with certain health conditions are at a very high risk. If they have malaria, if they're diabetic, high blood pressure, they are going to die much more readily than other women. So, and this might be because the health equity framework in terms of global health is not a very robust framework, but I think now that the health equity framework is becoming more rich, there's lots of things that can be done to look at this issue in the context of women's equality and particularly women's health equity. So with those two questions, I'll start.
We'll open it up for questions. I have two questions from students. Valentina Roman.
Yeah, thank you. I think my question's already been addressed mostly, but I know you mentioned in your paper, Marta, that the Supreme Court appears to be the sole sort of institutional space to recognize the pro-choice movement in Brazil. So I was wondering what your thoughts are on the prospects of success for the pro-choice movement in the upcoming basis, the Zika case and the decriminalization and social league space. So how do you talk about that?
Yeah, thank you, Rebecca, for the comments. Just a comment on your comment. I think you're right. I think what we see here is, from one side, the pro-choice movement was for a long time only talking about abortion should not be a crime, it's a public health question because there is a lot of unsafe abortion going on and a lot of maternal mortality going on. So this was the main focus of the feminist movement. Right to choose was very lateral, equality was in existence, so they were not really, they never recognized the idea. I think we should make interviews to understand better. Like, I think it was difficult to recognize that fetus life, that life of the fetus should be protected. Because to come to sit and discuss how other situations, they would have to say, okay, we agree that there is some degree of protection that we have, that we can do in other terms that not criminalization. I think the only case that they really addressed this issue of the effectiveness of criminal law in protecting fetal life was in the 2017 case. Also because we have a lot of international examples of this argument being used by courts, like the Portuguese court used exactly this argument. This is not the best way. We agree that we have to protect prenatal life, but this is not, criminalization is not the best way. So I think it was only here. And then in the side of the pro-life, it's really strategic. The protection of life is a strategic discourse to protect their moral values. It's a moral battle. It's a moral battle, and the moral battle now is politically very important. Because I go to the public sphere to talk about abortion, to talk about gender ideology, to protect the family, to protect the child, and I don't talk about inequality, I don't talk about corruption, I don't talk. So what we see now in Brazil is really this smoke, the moral discussion as really preventing the substantial discourse. I mean, I think Trump already, we see this in Trump, that it has a very strong populistic approach and a very strong populistic potential. So of course they are not really talking about public policy to protect prenatal life. About the prospects in the Supreme Court, I mean the prospects are in general, I'm very pessimistic in general. I was talking to Denise the other day. Our talk was almost a therapy session because I said there's no way out to feminist cause in Brazil. But what we have now is the executive stepped back since 2006. Dilma Rousseff in 2010 election, which was like the feminist president, a feminist president, a women president, she signed in 2010 election a letter to the people of God saying that although she had previously supported pro-choice positions, she will never advance any politics in that direction, and she fulfilled that promise in her 2 terms. And after the impeachment, we changed it from a neutrality of the executive to a executive very close to the pro-life, and a very misogynist government as well. The legislative, each election since 2006, the evangelical caucus and the pro-life and pro-family caucus is increasing. So the executive, the pro-lifes and the conservatives are really a majority in the executive. We face now a real possibility of approving a constitutional amendment to put protection of life since conception. I think it's a real risk now in Brazil, and the on-board statute, which would make us to come back to a total ban, what happened in other countries in Latin America. So these 2 arenas are totally closed. I would say, as I said in the paper, that the Supreme Court is the arena that is still open to discuss the pro-choice agenda. I interviewed people and I talked to people, and there are different diagnoses. Some people said during the impeachment process, the Supreme Court did had a very conservative role, and they will use the abortion case, and we had also a case on legalizing marijuana use. They use this case trying to come closer again to the progressive field of society, because they also want to regain their image as a progressive court. But also the impeachment process showed that the court has a great difficulty to assume a counter-majoritarian position. They were playing a lot with the public opinion, and abortion is, of course, a very, very controversial case in the public opinion. So I would say I am more pessimistic, and we had last month one ruling that made me feel more pessimistic about this case, which was a case that constitution, they were challenging if in public school because in the constitution the church got the possibility of having no mandatory religious class in public schools, and it has been interpreted that it should be showing different religions. It should be not doctrinal teaching, and the Supreme Court just decided that it can be doctrinal teaching. It can be used. The public school can have a space and a class to enforce Catholic or evangelical religion. So I think this judgment made me feel very pessimistic about the possibility of advancing abortion rights in this Supreme Court in this moment in Brazil.
Bianca Ponziani.
Yeah.
Bianca.
Yes.
Okay.
I can't talk though. I'm sorry. I can't talk.
Yeah.
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 I can't talk. I got gum surgery.
Okay. Okay. So anybody else? Eldon.
You mentioned, if I'm not mistaken, that the Supreme Court and the proceedings there have sort of been critical in the discursive shift among the religious conservative right from sort of a more religious discourse to a scientific and rights-based approach. And I'm wondering if you could sort of explain in a bit more detail how and why that's been the case.
Yeah, and I think that the court was a very important moment to consolidate this shift. They were if you see the public hearings, they were saying the pro-life was basically the pro-life position was basically defended by doctors that would even say that the fetus suffer pain or things like. If you see it from the medical point of view, very controversial positions, but still scientifically fundamented, that they try to show that an encephalic fetus could feel and could develop feelings towards the parents and answers and etc. So basically argued by doctors and or researchers on bioethics. It's also interesting how we from church, we also have these NGOs, we have pro-life NGOs, and we have a lot of NGOs on bioethics. And when we see it's a pro-life NGO. We have even that was a very interesting, when I saw it, I think Foucault would revolve in his tomb. I saw International Association for Biopolitics. And when you see it, it's a whole pro-life and anti-gender ideology. So they're not. It's not anymore a political, religious discourse. It's really scientific, or trying to frame itself as scientific, and a lot of use of rights, fetus rights, child's rights, human rights, and etc. So it's really a. I would say there is an Argentinian who is Juan Marco Vaggioni. He used this. He studies the same thing in Argentina, and he used this expression. It's a strategic secularism, of course, because in the background they are still confessional. In the background there are still a lot of evangelicals and Catholics, and we have espíritas in Brazil. I don't know if you know this, kardecists. It's a religion that they believe in reincarnation, so abortion would be really a huge question. We also have a lot of these small espíritas, NGOs advocating pro-life positions, but they would be doctors, espíritas, or lawyers, espíritas. It's not the church itself anymore. Carlos.
I'm here. This is all dealing with the emotional issue of abortion. And that's one of the reasons we don't have solutions, because there's emotion involved. But there is very damning statistics related to maternal deaths. So what energy is going to that? There's a lot of energy going to this. What energy is going to these massive health risks?
Nowadays, I would say very little. What we face nowadays after impeachment is like a diminishment of costs with health. And we don't have numbers yet, but I'm sure maternal health and the experiences of this kind of policies will be damaged. One of the first things the no-elected president did when he stepped in was to dismantle what we had a Secretary of Women. Lula created a Secretary of Women with a status of a ministry. He's dismantled this structure, and it's now a secretariat inside the Ministry of Health, and it's occupied by a pro-life women deputy. So we can, I would say that this government would not advance any policy regarding women's health. And I say, which is, I was talking to Rebecca last week, there is another thing that I think it's very important. All this battle against gender ideology in schools and the Supreme Court case and religious teaching, etc., it's really preventing sexual education, contraception policies. And if you see, like 2 weeks ago, the Lancet released the prospect to the Millennium Goals. And no Latin American country will meet the Millennium Goals in the issue of teen pregnancy. So it's going to be even worse if we think that they are really winning. They are winning this in Brazil. They are winning this battle against sexual education and contraception policies to teenagers. So I think these areas that should receive energy, it's not receiving anything. And I think it's really a question of electoral use and political use of this emotional issue.
Thank you, both of you, for your presentations. They're always very illuminating. And I have two questions, one for each. So the first one, I was really impressed by the how you portray the social mobilization dynamic. And I wanted, and especially this aspect that you highlighted about when the feminist movements became kind of working more at the institutional level, like in the Congress or in the executive, they lost space or they lost attention on the grassroots. And so my question is, when those organizations go back to the grassroots, from either side, does the discourse change towards the grassroots? Is it like, do feminist movements have a harder, now for example, have a harder task on human rights training on the grassroots movements, on women? How does that conflict with the pro-life discourse towards the grassroots on human rights? It seems like from a theory of rights perspective, rights are not any longer a trump card or salvation. And with regards to focusing on how to provide protections to prenatal life in accommodation with women's human rights, I've had the opportunity to interact in forum meetings of organizations, including people working in USA or JPA, of creating in the same way that the White Ribbon Alliance created a charter on the rights of women in childbirth, creating a chart of rights of neonatal or prenatal life. And while many of these rights that were being considered were pro prenatal life, but in accommodation of women's rights, there was a lot of concern of, given the global political context, how would such an initiative play for the opportunistic, populistic agenda of pro-life movement. So this, I know that these conversations are happening, but the fear of backlash is also very, very strong. So how to move forward?
Yeah, thank you for your question, Carlos. And I think you give me the opportunity to show also, because I finished very pessimistic. There are some people writing about backlash, and I think we are all feeling and living backlashes in different areas, but in gender and LGBTI movement, with Trump or with Temer in Brazil, we are now experiencing this moment. But I also like the narratives that doesn't show it as a irreversible and process. I like the narratives that really show that is a game of back and forth. And even for example, people who studied the military, okay, that's a parenthesis. People who studied the military dictatorships in Brazil would face repression and police repression as something that would suffocate movement, and other researchers that I like more, and I think they describe better what happened, they say how they also gave input to mobilization in the other side. Like the more repression, they made people to react in other bases. So I like this kind of I like better, and I want to have the lenses to see that the battle is not a big tsunami of backlash, but it's also something that involves a reaction. And in this scenario that I described, that the feminist movement was so institutionalized that they lost space in civil society and in the streets. We saw, for example, in a moment that we had an important advancement in the parliament, where the unborn statute started to pass. The feminists went to the streets, and we had like a new generation of young feminists that went to the streets with more radical discourse, and were really agglomerating a lot of people. It was called in Brazil the Feminist Spring in 2015. So it was a long time that we didn't went to the streets, and they were really talking about my body, my rules, and like a more radical discourse that was in play before. So I think it's a game, and it was the fact that we had a conservative advance also made some difference in the feminist movement, and we are and I think we are more mobilized right now in Brazil, for example.
Just to respond very briefly, Carlos in some ways is making the same point that you're making. There is a big global public health initiative to reduce maternal mortality, to reduce stillbirth, perinatal death, etc. It's a very, very significant effort. It's science-based. It's amazing. It's professional. OBGYN societies, societies of perinatal health are working in a very, very strategic, collaborative, scientifically based way to reduce, as a matter of public health, to reduce maternal mortality and to reduce perinatal and infant mortality. And the OBGYN's Federation of Brazil is in the forefront. It's very networked with all these groups, doing really impressive work. I think the problem is with the public health, and it's very necessary, it's a necessary but not sufficient condition. And the reason why it's not a sufficient condition is that it doesn't resonate with populism. It just, people working at the grassroots, these statistics are hard, they're hard to grasp, they're hard to understand. Perinatal death, you can hardly get the word out of your mouth. So when the debate is medicalized, it's very hard to get a broader movement. In addition, that debate is not in terms of women's equality, women's rights to their conscience, women's rights to call their souls their own, if one's going to look at that way. So these are two very, very different debates. Both are important, but the women's rights debate in some countries is a weaker debate. It's not as robust, it's not as enriching, it hasn't been, we haven't thought about it in ways to popularize it in I don't know whether this is the case in Brazil, but in many places it's not popularized. Equality is a very hard concept to understand, it's a hard concept to teach, it's a hard concept to learn. And so popularizing these kinds of debates is very, very necessary. And that's why I think Marta's work on mobilization, counter-mobilization, can really educate us as to how better to do this. So thank you.
On that note, please join me in thanking the speakers. So the next seminar is November 23rd. Vargas will be speaking about should parents be allowed to map the genome of their fetus, ethical reflections on the future of prenatal testing.